English Legal Criminal Dictation 100 WPM. Ready? Start. The present revision petition has been filed challenging the impugn order dated 22/9/2017 passed by Learned Principal Judge Family Court in MT 22/2015 and praying to set aside the same, whereby maintenance application filed by the petitioner was dismissed on the ground of res judicata. Stop. The brief facts of the case are that the marriage between petitioner number 1 and respondent number 1 was solemnized in the year 1990 and the parties last resided together up to January 1996. Stop. Two children were born from the wedlock, a son who has attained majority and a minor daughter. Stop. Since the time of separation, the parties have been involved in multiple litigations. Stop. Out of which one such case was filed under Section 125 CRPC in MT 22/2015. Stop. The petition by means of the second petition under Section 125 CRPC pray to direct the respondent to pay a sum of rupees 20,000 per month in favor of petitioner number 1 and also to pay a sum of rupees 10,000 per month in favor of the petitioner number 2. Stop. Further, by means of the petition, the petitioner pray for the court to award rupees 55,000 towards litigation expenses in favor of the petitioners. Stop. However, the said case was dismissed on the ground of res judicata void the impugn order dated 22/9/2017 on the ground that prior to the filing of the said petition, the petitioner along with her own two children has filed petition bearing number 289/1996 under Section 125 CRPC before the Court of ACJM Gurgaon, Haryana, which was decided wide order dated 16/4/1999, allowing each of the three petitioners a sum of rupees 500 per month as maintenance. Stop. It is stated by the learned counsel for the petitioner that on the date of filing of the present petition before the learned trial court, the petitioner was entitled to file a fresh petition as there was a fresh cause of action. Stop. He further argued that on the date of filing the present petition before the learned trial court, the petitioner was not receiving any maintenance as ordered on 16/4/1999 by the learned ACJM Gurgaon. The principle of res judicata was not attracted in the facts and circumstances of this case. Stop. He further argued that the claimants, if necessary, can file separate claims for maintenance each month. Stop. It is argued that wide order dated 16/4/1999 maintenance was granted only from the date of filing of the said claim petition. Stop. It was however mentioned in the said order that it shall operate either for future or till further orders. Stop. It was also submitted by the learned counsel for the petitioner that it cannot be presumed to be operating beyond the date of decision of the maintenance petition number 279/1996. It was stated that petitioner was entitled in law to claim monthly maintenance post January 2015. Stop. Section 127 CRPC is not the proper resource since the maintenance period claim in the maintenance petition filed on 7/1/2015 was for claiming maintenance from January 2015 onwards. The observations made in the impugned order read as follow. The judgment relied upon in support by both the councils decided by Manipur High Court and Kerala High Court shall be read in the context of their factual background. Stop. In both these cases, petition under Section 125 CRPC was filed a second time. Stop. In none of the two cases, the first petition filed under Section 125 CRPC was decided on merits awarding maintenance. Stop. In both these cases, earlier petition filed under Section 125 CRPC was dismissed for one or the other reason as mentioned in the said judgment. Stop. Hence, the Honorable High Court held in the two cases that principles of res judicata shall not be applicable. Stop. However, in the instant case, the earlier petition of the two petitioners herein for their maintenance was filed under Section 125 CRPC in the court of ACJM by the said court awarding maintenance rupees 500 per month each to each the two petitioners and also to the minor son. The petitioner withdrew the amount of maintenance sometimes up to 2002 and they have now filed this petition under Section 125 CRPC for the wife and the daughter afresh, leaving the son for the reason of his attaining the age of majority. Stop. In this background, the proper course of action to the petitioners is to initiate proceedings under Section 127 CRPC for the alteration of the amount subject to the satisfaction of the conditions in that provisions of filing the petition under Section 125 CRPC afresh. Stop. In this regard, this court also find support from the judgment of Manipur High Court relied upon the respondent wherein it has been held that there is no provision in the code which bars a second application under Section 488 CRPC. Stop. It has observed that but when an application under this section has been heard and adjudicated under this section has been heard and adjudicated upon, it is against the general principle of the rule of res judicata that a subsequent application on the same fact should be entertained. Stop. The Honorable High Court held that subject to this a prior application does not bar a subsequent application if the prior application was dismissed for default without adjudicating on the merits. Stop.